Clause number 2000. Oh, hold on a minute. 2018 0D06416 and 2022 0D02805. The state of Texas versus Raymond John Coker. Kocher. Am I pronouncing that correct?
Yes.
Okay. And that is your true and correct name, sir?
Yes, sir.
Your date of birth is 1/5 of 1994. And you recognize your attorney there, Mr. Solis? And Mr. Solis, you recognize your client, Mr. Coker?
I do recognize him.
All right. Ms. Espinosa, I believe this is a plea agreement case. Would you please state the agreement on the record?
Yes, Your Honor, it's 2 3 years TDCJ on the revocation in the 2018 0D06416 case to run
Okay, so
concurrent.
a plea of true in the older case, and how much time?
3 years TDC, Your Honor.
Okay. Got it. And then the
And
newer
it's-
case?
Yes, Your Honor, it's running concurrent. On the new case, one of the counts was a first degree. We're reducing that to a second degree. Also 3 TDC. And I'm dismissing count 3, Your Honor.
So we're going to go on a lesser on count what?
Count 2?
On count 2. And that's going to be a second degree. And that's also going to be 3 TDC. And that's going to run concurrent. And then you're going to dismiss counts what?
Just count 3, Your Honor. He's pleading to count 1 and 2.
On count 2, however, there's a lesser included of possession, of possession only and not delivery to make it a 2 to 20.
Right.
Otherwise, it'd be 5 to 99.
Right. Okay. Now, is that your understanding of the plea agreement, Mr. Solis?
It is.
Is it also your understanding of the plea agreement, Mr. Coker?
Yes, sir.
Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it? Should I choose to be harsher than that, you could withdraw your pleas. We could proceed to a trial, to a jury on the one and a motion to revoke on the other. But if I follow the plea agreement, it is final. You cannot withdraw your pleas. You cannot appeal these cases without my consent. You would be transferred to the Texas Department of Corrections at their earliest convenience to serve out whatever would remain of these sentences. Do you understand? Okay. Now, we have in front of us some documents marked in the one case, State's Exhibit 1, the guilty plea and waiver forms. That's the new case. And in the older case, stipulation and waiver forms on the motion to revoke. These documents bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you, in fact, sign these documents?
I did, sir.
Did you read them before you signed them?
Yes, sir.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of these documents?
Yes, sir.
Did you have any question about their meaning?
Yes, sir.
So if there's never any question, let me briefly explain to you what they mean. On the new case, the guilty plea and waiver forms are simply telling me that you're coming into court here telling me through a judicial confession, yes, Judge, I did commit this offense and at least the lesser included offense in count number 2 of possession of the controlled substance, and also telling me that you were giving up the several valuable rights, the most important of those, the right to a trial by jury in that case, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, sir.
Understanding that, then how do you plead to that indictment, guilty or not guilty?
Yes, sir.
Okay, now in the motion to revoke, that the stipulation and waiver forms, stipulations are merely agreements between yourself, your attorney, and the state's attorney that certain facts are true. Basically, that you were on probation. While on probation, you did not follow all of the terms and conditions of your probation, primarily committing another offense, another felony offense while on probation. And then waiver forms telling me that you're giving up the right to have a full evidentiary hearing and confrontation where the state would have to prove by a preponderance of the evidence to me that you had in fact violated your probation. You understand that?
Yes, sir.
Now, understanding that, how do you plead to the motion to revoke then, true or not true? Are you entering your pleas of guilty and true freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead either guilty or true? Did anybody force you, coerce you? Well, no. Did anybody promise you anything or in any way convince you that you had to plead either guilty or true, other than the plea agreement stated on the record in open court this afternoon?
No, sir.
Now, you understand on the motion to revoke that that was a third-degree felony. And so
Sure.
let's see, on that one, he is on, what is that? Is he on 2 years probation on that straight?
Straight probation, yes, Your Honor.
Great probation.
2?
Yes,
Okay. Then on the other one, the count 1, I believe, is a third-degree felony.
the
Second.
second degree, Your Honor.
Second, and then the count 2 is now the lesser is a second-degree penalty,
Correct, Your Honor.
not less than 2 nor more than 20 years in prison, a fine not to exceed $10,000. You understand? I've got to sentence you somewhere within those general guidelines. Now, you are still a U.S. citizen. Excuse me, I couldn't hear you.
Yes, sir.
Okay. And how old are you now?
29.
29?
Yeah. How far did you go in school?
I graduated high school, Gotham College.
And so you certainly can read and write the English language.
Yes, sir.
Have you ever been under the care of psychiatrists or psychologists for mental health or mental illness issues?
Yes, sir.
Okay, in fact, we went over that before at the previous plea. I think you mentioned anxiety, bipolar, things like that. Is that has that changed any?
No.
Are you presently under any medications for mental health, mental illness issues today?
Yeah, I'm taking medication.
Okay. Are those things helping you?
I believe they are, sir.
Are they helping you to such a degree that you believe you are mentally competent today, that you understand everything that's going on?
Yes, sir. I understand everything that's going on.
And in counsel, you've had time to go over the facts and circumstances of these cases, the legal aspects of them, and had time to evaluate your client's mental status.
I have, Your Honor. He's been very involved in all details, instructions and a path forward in all the negotiations. He's been very involved in that.
All right. So, well, then, based on your representations, Mr. Solis, your representations, Mr. Coker, the court's observations of you in court, both here today and prior occasions, find that you're competent to enter these pleas. The state may summarize the evidence.
Yes, Your Honor, had the state proceeded to trial in this case, under the 2022 0D0 2805 case, the state would have proven beyond a reasonable doubt each and every element under count 1, manufactured delivery of a controlled substance, penalty group 1-B, more than or equal to 1 gram, less than 4 grams, and count 2, the lesser included offense of possession of a controlled substance, penalty group 1, more than or equal to 4 grams, but under 200 grams. The state moves to introduce states exhibits 1 through 2, which are the plea papers and the 3914 disclosure form under that case number. And additionally, Your Honor, had the state proceeded with the revocation of the defendant's probation under case number 2018 0D0 6416, the state would have proven beyond a preponderance of the evidence that on July 23rd, 2020, the defendant pled guilty to the offense of prohibited substance or item in a correctional community facility, and was assessed a sentence of 10 years TDCJ, probated for 2 years. However, he then violated his probation on May 8th of 2022 by violating condition A and unlawfully committing the offense of manufactured delivery of a controlled substance, penalty group 1-B, more than or equal to 1 gram, less than 4 grams, and then the lesser included offense of possession of a controlled substance, penalty group 1, as alleged under cause number 2022 0D0 2805. The state moves to introduce states exhibits 1 through 2, which are the state's motion to revoke probation and the waiver of appeal, Your Honor.
All right. Any objection?
None, Your Honor.
Received. Based on the evidence before the court finds the evidence sufficient to revoke or find the allegations true in the older case on the motion to revoke, and I find them true, and I revoke the defendant's probation. And the new case, the newly indicted case, I find the evidence sufficient to find the defendant guilty in both counts 1 and 2, but in count 2, I find him guilty only of the lesser included offense of possession of the controlled substance. I am ready to proceed upon the issue of punishment. Now, when we talked on your initial plea, you had some employment in New Mexico. You indicated that I believe you did have a girlfriend, that she was very supportive. You didn't have any children. Then later in 2021, you were still talking about having a steady job as a metal factory operator, machinery operator. You had a relapse at some point, and you're going to live with your father, I don't know, with father's friend or something. What happened here? I'm particularly interested on this issue of the fentanyl, because I'm contemplating looking at trying to come up with some program to do something about fentanyl. And what is it about that drug that is so addictive or gets people into that?
Well, Your Honor, when after I got kicked, I left my dad's friend's house. It was his old Marine Corps buddy, and he took me in. After I left, I was homeless, and I went to go live at the OC, and I was shot in the leg. And so I self-medicated on fentanyl.
All right. Now, when you get out, what are your plans?
Hopefully that I can try to get some kind of interstate compact and go to Las Vegas to my family. I don't currently I have nothing in Texas. I don't got no girlfriend anymore or friends or family or anything like that. So the interstate compact would be to go to my parents.
I've talked to his mother, Your Honor, frequently. She is in Las Vegas, and they are receptive to receiving him back home in Vegas when he gets out.
Okay, we're speaking of Las Vegas, Nevada, not Las Vegas, New Mexico.
Correct.
Okay. All right. Well, that is a good plan. And once you do have some skills. Obviously, you've had some jobs that are more than, minimum wage type jobs. So hopefully you will be able to get reemployed and get back with your family and put your life back together. And I hope it all works out for you, sir. So I will follow the recommendation, 3 years to serve in the Texas Department of Corrections on both cases. Those cases will run concurrent. And I will give you full credit for all the time that you have served, going back to the initial case. And at least in that case, I can give you time that in based on your initial arrest way back even in, where is it? Maybe, what was it, 2019, 2020, somewhere in there. Okay. Anything else?
No, Your Honor.
Okay. Well, good luck to you, sir. Take care.
Nothing from this hearing.
All righty. Very good. Thank you.
Maybe
Well,
excuse, Your Honor?
Yes, you may. Let's proceed on Mr. Setaceres then. This is a bond here.
Good afternoon, Judge.
Good afternoon. I have had an opportunity to look at the public safety report. I have it in front of me. Have reviewed it. During the defendant's history. Issues. Okay. This is cause 2022-0D0-2800. This is a robbery case, is the allegation. We did do the judge's pretrial back late last year. And so I was given the facts of the case, had to do with some kind of a fight in the middle of the street with someone. And what's the defendant's present bond?
You know, Judge, that's the,
It's 10,500 surety, Judge.
Okay. And how long has he been in jail as of today?
174 days, Judge.
And Your Honor, I'm not sure, I'm not sure if the court has the state's current recommendation.
That I did not have it based on the September 6th hearing. Do you have a rec now?
Yes, Your Honor, it's 5 years deferred probation. No contact with the complaining witnesses.
Well,
Never.
obviously, yes. So, Mr. Morales, you've gone over this with your client. He has not had the ability to make this bond, and it is the defendant from here. Do you want to give me a proffer as to what we have going on with the defendant? I do have his criminal history, which unfortunately he does have some where he has been. It looks like he's gone to prison once before. Correct?
that is correct, Judge. I know that Mr. Seta said his mother lives here in El Paso, that he is a high school graduate. He denies any history, any mental health issues in his past. He was kind of having some difficulty finding a permanent place to live. He'd stayed with his mother, but that was no longer an option. And then he had been at, from hotels to sleeping in the cab of a diesel truck. I know that he had maybe been in some of the local shelters. What we were hoping is, Judge, that new recommendation, I spoke to Mr. Setacetis this week. I had not conveyed the new recommendation to him. We were hoping, of course, maybe a lesser included offense on the robbery, a lesser included offense of theft and time served, given the amount of time that he'd been on probation. I know that Ms. Espinosa and I had discussed that, but there were some concerns on her end, I guess, that she was echoing from the complaining witness. I hadn't had a chance to talk to him about this one. It was just the idea of him being in custody for darn near 6 months, Judge, that we were trying to get him moved and trying to get him with a stable place to live, Judge.
Do you have if I let him out on bond, does he have somewhere where he's going to be able to stay, where we could be able to, that you all would be able to contact him? And I mean, because if he doesn't have anything, when he gets out, he may not even have a cell phone or anything to be able to communicate with you all.
And that continues to be a problem, Judge, because he can't live with family. And we've been having some difficulty placing people recently at shelters. Judge, I'm thinking we might be able just to resolve this case, and maybe the bond issue isn't something we need to even get to. Maybe we resolve this next week, Judge, and just resolve it with a plea.
All right, that might be easier, and then the probation department, can get someplace where he can stay, and maybe by then some of the pressure of the housing in El Paso will have eased a little bit. It seems to be getting a little better.
No. And Judge, I'm not sure if this is the last one that you had for the day. I was hoping that maybe Michelle could put us in a breakout room so that I could briefly talk with Mr. Setacetis about.
Yes, why don't you do that? Why don't you talk with him and see if you want to let me, because I probably